Hi, I'm Rex Whitford, a specialist SMSF advisor who's been assisting trustees to unlock the full potential of their funds for the past 10 years. Welcome to our series of presentations on the many aspects of running an SMSF. In today's presentation, I'll be talking about estate planning and how to effectively link your estate plan to your self-managed super fund, also known as an SMSF. It is vitally important that you remember that this presentation is general advice only and should not be relied upon as a substitute for seeking personal advice from a suitably qualified professional, such as an accredited SMSF specialist, advisor or lawyer. So what is estate planning? Well, estate planning is a term used for planning and documenting your decisions while you're alive for when you die. While you're alive, your estate plan will document who has the authority to make decisions on your behalf. If you are physically or mentally disabled, what instructions would you like to provide for your ongoing care and medical treatment? What limitations, if any, would you like to place on this authority? When you die, your estate plan will document how you would like your assets distributed. Who will be your guardian for minor children? How to make provision for a family member with special needs? Who will be the executors or trustees of your estate? In this session, we'll not be covering all aspects of financial estate planning, but we will focus on how you can link your SMSF to your estate planning. Now, an SMSF is a form of superannuation, so it's important to have some background knowledge of some of the rules with superannuation death benefits, a very complex part of the law. SMSFs are a form of superannuation, and as such they're regulated by the Superannuation Industry Supervisory Act 1993. We call this the SIS Act for obvious reasons. The SIS Act defines who can receive death benefits from your SMSF. The SIS Act states that a death benefit can be provided to the dependents of the superannuation member. It is important that the member specifies their preferred dependents so the trustee of the superannuation can pass the death benefits to the correct beneficiaries. Many superannuation members are surprised to find that their will is completely ineffective when it comes to disposing of their superannuation benefits on their death. The SIS Act defines who can be dependents of a member, and it includes the spouse of a member, any child of a member, anyone financially dependent on the member, anyone with whom the member has an interdependency of relationship. This chart shows who are defined as dependents under the SIS Act. If a member does not have any dependents, the trustees of the superannuation will seek guidance from the member's executor in their will to help decide who will receive death benefits. An interdependency relationship exists between two people if they have a close personal relationship and they live together and one or each of them provides the other with financial support and one or each of them provides the other with domestic support and personal care. Therefore, an interdependency relationship may also include same-sex partners who may already be legally classified as dependents anyway, or siblings or friends who reside together, or an adult child who resides with and cares for an elderly parent. So now we know the SIS Act defines who is a dependent, but interestingly, it's the Income Tax Assessment Act that determines the tax benefit paid from the superannuation. The Tax Act has a different definition of dependents, so let's have a look at the chart again to see where the Tax Act differs slightly in its definition of who pays tax and who does not. Now, I've highlighted on this chart that adult children and adult stepchildren will pay tax on superannuation death benefits. So officially, Australia doesn't have any death duties. However, Changes to tax and superannuation death benefits made in July 2007 will result in a large amount of tax on death benefits when it moves from one generation to another. So now we know who pays tax, let's look at how much and what they can do to minimise the tax. Superannuation death benefits paid to children over 18 will be divided into two components: the tax-free component, the taxable component. Naturally, the tax-free component is, well, tax-free, and the taxable component is taxed at 15% plus Medicare levy, so 16.5%. For example, a superannuation death benefit with a taxable component of $540,000 to an adult child would be reduced by a tax of $89,100. So what can we do about reducing or eliminating the death benefits tax? One way is by undertaking a recontribution strategy. In summary, a recontribution strategy involves the member making a withdrawal from their superannuation and contributing the amount back in as a non-concessional contribution. Now, this strategy has some strict rules and conditions to follow, so I suggest you seek advice from a financial advisor to help you plan this. Document and implement the strategy. To be able to undertake the recontribution strategy, you need to be aware of a few rules. You need to meet a condition of release for the superannuation. Potential tax on withdrawals for members under age 60 you need to consider, and the eligibility to recontribute the superannuation and the limits on the non-concessional contributions back into the super. If you are eligible for a recontribution strategy, an amount of $540,000 recontributed could potentially save tax of $89,100, providing a substantially greater death benefit to be paid to adult children. Members have three methods to nominate their beneficiaries. 1, a binding death nomination. 2, a non-binding nomination. And 3, an automatic reversionary pension. A binding nomination removes the trustee's discretion and is binding on the trustees of the self-managed super fund to pay the death benefits to the dependents that the member has nominated. Now, the disadvantage of a binding death nomination, there's a few. They are the inability of the trustee to rectify the situation where a member has not kept nominations up to date, so keep them up to date. For example, the family situation may have altered due to births, deaths, children becoming independent, remarrying, etc. If the member is unlikely to keep the nomination up to date, a binding nomination allows the trustee greater flexibility. And if not properly thought out, a binding nomination may have costly tax consequences. Also, incomplete or incorrect binding death nominations will be invalid, thus will not fulfil the member's intentions. Many self-managed super fund trustees do not permit binding death nominations, particularly if the trust deed is dated prior to 1999. Trustees of self-managed super funds should check their trust deeds to see if they are permitted to have binding death nominations. It's suggested that SMSF trust deeds be updated regularly to deal with changes in the superannuation rules. Another disadvantage of binding death nominations is when a stepchild is nominated, particularly an adult stepchild who is not financially dependent. This issue is particularly relevant to blended families. The ATO issued a determination on the 21st of October 2011 stating that a stepchild ceases to be a dependent when the legal marriage of the natural parent and the step-parent ceases. For example, if they divorce or the step-parent dies. Here's an example. Here's a story of a man named Brady, Mike and Carol. They're married, and this is their second marriage for both of them. Mike has 3 children, and Carol has 3 children. Mike and Carol each have superannuation benefits. When Mike and Carol are alive, all 6 children are dependents of both the natural parent and the step-parent under the SIS regulations. The issue arises when they both die. Let's say Mike dies and his superannuation is paid to Carol. Now his children are no longer classified as Carol's dependents under the SIS Act. So when Carol dies, Mike's children cannot receive any superannuation benefits directly from Carol's super fund. If they intended all the superannuation benefits to be distributed equally between the 6 children, they need some specialised estate planning. Other questions may need to be considered. What if Carol remarries? Does Mike's super find its way to his children? How could Mike leave his death benefit equally if some children were adults and pay tax and some were 18 and pay no tax? And what about Alice, the housekeeper? Is she a financial dependent? Let's have a look at non-binding death nominations. These are also known as discretionary or preferred nominations. This method allows the trustee the discretion to pay superannuation death benefits to dependents nominated by the member. The trustee could override a non-binding nomination. For example, if another dependent of the deceased who has not been nominated to receive any benefits can demonstrate an equal or greater expectation of support from the deceased member, the trustee may decide to pay some of the superannuation benefits to that dependent. An automatic reversionary pension refers to a pension that is established with a specific nomination that upon the death of the original pensioner, the pension automatically continues to be paid to the nominated person. This also removes the trustee's discretion, as long as the nominee is eligible to receive a death benefit pension. Some advantages of an automatic reversionary pension are: provided the reversionary pension is eligible to receive a death benefit as a pension, then the trustee is obliged to continue the payment of the original pension. As the pension continues, there is no need to pay a lump sum tax out of the SMSF. Sometimes the beneficiary is not able to recontribute a lump sum benefit back into superannuation, resulting in it being taxable outside of superannuation. Benefits are exempt from being taxed, so an automatic reversionary pension continues as a tax-exempt pension. There is also less paperwork and is therefore less traumatic for the surviving SMSF trustee, which is usually a family, a relative. Some of the disadvantages include an automatic reversionary pension must be created when the pension is established. There may be some Centrelink advantages with an automatic reversionary pension. Only certain beneficiaries are able to receive a reversionary pension, including a current spouse, a child under 18, a child under 25 who is financially dependent, or a disabled child of any age. A reversionary pension to any child must be cashed when they turn 25 unless the child is disabled. There are a couple of SMSF rulings and precedent cases that we can learn a lot from. Now the first is Donovan and Donovan. 2 years before he died, Mr. Donovan, as trustee of his SMSF, wrote a letter expressing his wishes that the proceeds of his member account be left to his daughter via his will. Mr. Donovan's widow is the remaining trustee of the SMSF. Now, the widow argued that the letter did not constitute a binding nomination because it was not made in accordance with the SMSF trust deed, which stipulated that the binding death benefit must be in the form required by the legislation. Therefore, the letter was ineffective as a binding death nomination, and the widow, as the remaining trustee, was able to pay the deceased husband's benefit to herself. Now, the ATO had previously stated that in its opinion, the regulations regarding binding death nominations generally do not apply to everyone's SMSFs, But in this case, the court found that binding death nominations do apply to SMSFs and agreed that a letter was not a binding death nomination. Unfortunately, Mr. Donovan's daughter missed out on her inheritance. This next example is a quite well-known case where the beneficiaries of a will were surprised to find that the will was completely ineffective when it came to disposing of the superannuation benefits of the member. In the case of Katz and Grossman, in 2007 in the New South Wales Supreme Court, Mr. and Mrs. Katz were individual trustees of their SMSF. Mrs. Katz had died and Mr. Katz, the surviving trustee, needed to add a replacement trustee, as SMSFs with individual trustees must have at least 2 trustees. He appointed his daughter as a replacement trustee. Mr. Katz also had a son, and in his will he left a direction that the $1 million in his SMSF member account be split equally between the son and his daughter. Upon the death of Mr. Katz, his daughter, as the remaining trustee, appointed her husband as the replacement trustee. She did not take into account her father's will and paid his member benefit to herself. Now, the son challenged her decision. However, the New South Wales Supreme Court held that she was entitled to take this action under the rules of the trustee, and the will was ineffective to stop her. So we suggest trustees and members of SMSFs take these 7 steps to link the SMSF to their estate planning. Step 1. Consider the best trustee arrangements for them, individual trustees or corporate trustees. Step 2. Identify the rules that govern the SMSF. Step 3. Determine the superannuation benefits available. Step 4. Ensure a will has been made. Step 5. Ensure an enduring power of attorney is in place. Step 6. Engage professionals. And Step 7. Record relevant SMSF information and keep records. Now let's have a look at Step 1. Consider the best trustee structure for your SMSF. When establishing an SMSF, one of the first issues to consider is whether the trustee structure should be either an individual trustee or corporate trustees. According to the ATO website, the recently completed CUPA review found that 70% of existing SMSFs have individuals as trustees rather than corporate trustees. The report also revealed that in recent years, almost 90% of SMSFs have been established with individual trustees. Now, these statistics are somewhat surprising when considering the advantages of a corporate SMSF trustee. Many SMSFs are established with individual trustees simply because of the lower costs. And in the case of a single member SMSF, the member will be a trustee, but they must arrange a second trustee. All members of an SMSF must be trustees. However, not all trustees must be members. So, the SMSF has 2 individual trustees and one dies. A replacement trustee must be arranged because although the SMSF has a single member, it cannot have a single trustee. If the trustees change, then the registered name on every asset owned by the SMSF must be amended. Therefore, in the event of a death or loss of capacity, individual trustees are often not the best option for estate planning. A corporate trustee is a registered company. Ideally, the company does not trade and has the sole purpose of acting as trustee. With a corporate trustee, it's easier to ensure that the SMSF assets are kept separate from the personal business assets of the members. It is possible for a single member SMSF to have a sole director of a corporate trustee. If the SMSF has a change of members, a corporate trustee remains unchanged. This means that when a member changes, the ownership of the assets of the SMSF will not need to be amended. A corporate trustee continues to function after the death or incapacity of a director. Therefore, the control of an SMSF can continue even after the death of a member. Another advantage of a corporate trustee is that companies have the benefit of limited liability. So directors are not liable for the debts in the company. For example, if they're subject to litigation, let's say a person injures themselves on a property owned by an SMSF, a corporate trustee provides protection by limiting the liability to the assets of the company and not the directors. Now, in the case of Katz and Grossman earlier, had Mr. Katz appointed a corporate trustee instead of his daughter as the second individual trustee, the son may have received his inheritance. Now, here's another example of where a corporate trustee may have been beneficial. Shale versus the ATO. Now, Mr. and Mrs. Shale were individual trustees of their SMSF. The SMSF had assets totalling around $3.5 million. Mr. Shale sold and withdrew almost all the assets of the SMSF and left Australia. Mr. Shale was not eligible to have withdrawn his superannuation as he had not met a condition of release. After several years of court cases and appeals, the ATO successfully made the SMSF non-compliant and imposed a tax penalty of 46.5% of the assets of the SMSF. As Mrs. Shale was the only remaining individual trustee, she became personally responsible to pay the tax penalty. As the SMSF now had no money, Mrs. Shale had to sell other assets to pay the ATO tax of around $1.6 million. Had Mr. and Mrs. Shale had a corporate trustee, Mrs. Shale's personal assets may have been protected. So let's have a look at step 2, identifying the rules that govern the SMSF. Now these rules can be found in the trust deed when establishing the SMSF or the most recent deed of variation. Trust deeds executed before the 1st of July 2007 generally do not allow members all the benefits of simple super reforms. For example, the transition to retirement pensions and the ability to borrow in limited circumstances. Older trust deeds may not allow binding death nominations to be made. It is prudent for the trustees of the super funds to regularly review their trust deeds and update if necessary. So step 3, determine superannuation benefits available upon the death of a member. When a member of an SMSF dies, the surviving trustee needs to identify the value of the deceased member's account at the date of death. The member may have had life insurance that will need to be claimed. Consideration must also be given to the liquidity of the SMSF. If the SMSF has relatively illiquid assets such as property, it may be difficult to pay a lump sum to the beneficiary of the deceased member. Assets of the SMSF may need to be sold to pay a death benefit, which may result in realising a capital gain, which may result in a liability to the SMSF. Now, most SMSFs prepare annual reports at the end of the financial year, so trustees may need to seek assistance from their administrator to calculate and manage the deceased member's death benefit. Step 4, ensure a will has been made. We encourage everyone to have a will, but it's particularly important for the trustees of a self-managed super fund to appoint who will become the trustee or directors of a corporate trustee upon the death of a member. Usually a trustee will explain how a trustee can be replaced. Often the surviving spouse will be the remaining trustee and also the executor of the deceased. However, with individual trustees, a widowed spouse is unable to act alone, so must appoint a second trustee or a corporate trustee. Replacement trustees and directors must consent to their appointment, and it's important that they can work with the existing trustees and members of the SMSF to avoid conflicts. The death benefit of a member may be a catalyst for the remaining members to consider the ongoing suitability and the future of the SMSF. Perhaps the SMSF should be wound up. Step 5, having an enduring power of attorney in place. Each member of the SMSF should have an enduring power of attorney in place so that in the event of incapacity, provision has been made for an appropriate person to step in as trustee and protect the incapacitated member's benefits. Now, in the case of a single member fund, an enduring power of attorney will provide the legal capacity for a replacement trustee to operate the SMSF and fund the level of care they require during incapacity. In addition, a trustee of an SMSF cannot continue to act as trustee or director if outside of Australia for an extended period of time. Step 6. Engage professionals to get advice. Draft the relevant documents and implement the appropriate structures. Trustees and members of an SMSF need advice and assistance to manage their SMSF in a compliant and efficient manner. All of the responsibility of paying benefits to members and members' beneficiaries lies on the trustee of the SMSF. So it's vital that the trustees have the knowledge, experience and ability to act correctly. The SMSF trustee should be prepared by a lawyer. Now, it's important to know that not all trust deeds are the same, and often a trust deed needs to be tailored for the specific needs and circumstances of the members of their family. Your lawyer should also prepare the wills, enduring power of attorney and binding death nominations. An accountant should be engaged to establish the corporate trust deed and to assist with administration. Tax returns, tax advice and succession planning for other entities. A financial planner who is an SMSF specialist advisor can review your documents and records, provide advice during recontribution strategies, pension strategies, Centrelink, and arrange life insurance and disability insurance within the SMSF. Engaging professionals can ultimately result in a smooth transition of benefits to the intended beneficiaries in the most tax-effective manner. The last thing a deceased member would want is family rifts caused due to the disagreement over estate legacy. Step 7. Recording relevant information and keeping records. It is critical that the trustees keep good records. Records of an SMSF need to be held for up to 10 years. An estate dossier is very handy to record the whereabouts of the will, the powers of attorney, also the professionals who have been involved in the planning and the person's estate, such as their lawyer, accountant and financial advisor. Remember, good advice and education puts you in control of your financial future. As an SMSF specialist advisor, I can provide you with the information and support needed while you control and direct your self-managed superannuation fund. I'd like to encourage you to view our other educational presentations that are available on our Wealth for Life financial planning website. If you feel that we may be able to help you, then please contact us for a consultation. We'd be more than pleased to meet with you in person at our office. Now, we also assist Australians all around the country and overseas. Thanks to Skype and our use of technology, no one is too far away to assist. We look forward to assisting you achieve your financial goals. Thanks for listening and enjoy the rest of our presentations on the website.